Good morning. Okay, now we are going for electronic signature certificate. We have discussed about this digital signature certificate and after that electronic signature. Now we are going for electronic signature certificates. So when you are going to get this electronic signature certificates, okay, we have to take into account the following things. First one is issue of certificate. Second one is suspension of certificates. Third one is revocation of certificate. These are the three things that we will come across when we are going for this electronic signature certificate. Now, the first one is issue of certificate. Who will issue this electronic signature certificate? Okay, the central government of India, they will give this electronic signature certificate. The central government has prescribed a form through which any person can apply for the issue of an electronic signature certificate to the certifying authority. So the central government people they have issued a form, application form, through which any person can apply for the issue of electronic signature certificate by certifying authority. The fees for such application is not more than rupees 25,000 and it is to be paid by the applied person to the certifying authority. Suppose whomever they want this electronic signature certificate, they have to pay 25,000 rupees to the certifying authority along with the application form. There would be different fee for different classes of applicants, which is also prescribed by the central government. Okay, you'll come across different forms, application forms for different purposes, and this thing it will be given by the central government. The certifying authority will issue the certificate after verifying and ascertaining the needed information. So don't be of that opinion that the certifying authority will blindly give the certificates after taking into account the application forms. They'll verify and ascertain what is the necessity, what is the need, what is the necessity for that. The certifying authority will issue the certificate after verifying and ascertaining the needed information. The issuance is usually based on the satisfaction of certifying authority. Some of the conditions are what are the conditions that we come across? The applicant should have a private key in correspondence with public key to be listed in electronic signature certificate. They will take into account first of all whether the applicant is having a private key along with public key. Okay, you have to allow that. You have to take into account the private key as well as public key. The applicant should have a private key in correspondence with public key to be listed in electronic signature certificate. The applicant should have the ability of creating an electronic signature, which is possible if he holds a private key. The applicant's public key and private key combines a key functioning pair. So these are the various conditions that we come across when we go for this electronic certificate, electronic signature certificate. These are the conditions. First one is they must have private key as well as a public key. Next, second one is ability of creating this electronic signature, which is possible if he holds a private key. There should be a private key. Then only he can go for this electronic signature certificate. That is the second one. And the third one is the applicant's public key and private key combines a key functioning pair. That is, both the private keys and public keys must be combined. Okay, he must have that capability to combine both private key as well as public key. This is about the issue of certificate. How they now the next one is suspension of certificate. Okay, every authority. One thing you have to keep in mind is every authority it will rely on central government as well as certifying authority. If certifying authority if it is not satisfied, then it will inform to the central government that this certificate application form is not up to mark and you can suspend that. So suspension of certificate. The electronic or digital signature certificate might be suspended by the certifying authority in the following cases. Okay, when they will suspend this. Okay, first one is the certificate might be suspended on receipt of a request to that effect from the following. The certificate might be suspended on receipt of not a on respect might be suspended on receipt of a request to that effect from the following. First one is the subscriber listed in the digital signature certificate or any person who is empowered to act on behalf of that subscriber. Okay. And next, the certificate could be suspended if it is in the public interest. The certifying authority might be able to not to suspend the certificate if the period exceeds 15 days before informing and giving chance to the subscriber to prove himself. Okay, the first one is the subscriber listed in the digital signature. Already, when the person is listed in the digital signature certificates, or any person who is empowered to act on behalf of that subscriber, that is a third party. That is a third party, any person who is empowered to act on behalf of the subscriber. This is especially when we go for this minors case. Okay. Next, the certificate could be suspended if it is in the public interest, not for private. Digital signature or electronic signature, it is completely and it is purely for personal purpose, not for public purpose. Okay. If it is in the public interest, the certifying authority might be able not to suspend the certificate if the period exceeds 15 days before informing and giving chance to him 15 days before informing and giving chance to the subscriber to prove himself. The subscriber must prove himself and the certifying authority will give 15 days time period. Next, third one is revocation of digital signature certificate. Revocation, rejection. Okay, revocation. The digital signature certificate approved by the certifying authority might be revoked in the following cases. First one, when a subscriber or any other person is empowered to make a request to the effect, when a subscriber dies, or when the dissolution of firm takes place. These are the three things when the certifying authorities, okay, they can reject. That is, they can revoke. Okay. So once again, I'm reading that the digital signature certificate approved by the certifying authority might be revoked in the following cases. First one is when a subscriber or any other person is empowered to make a request to that effect, when a subscriber dies, or when the dissolution of firm takes place. These are the three cases where the certifying authority can revoke the digital signature certificate or electronic signature certificates. Now, after that, penalties and adjudication powers. You have to go for penalties. Suppose if anything goes wrong, what are the damages? What are the penalties that they have to pay? Penalty for damaging computer system. First one is okay. A person is liable to pay a penalty for damaging the computer system without the owner's permission or in any of the following acts. Okay, a person is liable to a penalty for damaging the computer system without the owner's permission in any of the following acts. First one is access, uses confidential data without authorized permission, accesses, uses confidential data without authorized permission, downloads, copies, or extracts data without prior permission, destroys or removes data from computer system, disrupts the working of the computer, introduces computer virus in the system purposely. So these are the cases where you will come across a penalty. And what is the penalty that we will come across? Okay, I mean, assist any outsider in performing any unauthorized and illegal act. Okay, this is where the person is supposed to be or subjected to be a penalty. He has to pay a penalty. He is liable to pay a penalty. Next, penalty for loss of data due to negligence. You see, whenever the data is due to negligence, ignorance or negligence, okay, not ignorance. Actually, it is not ignorance, please. It is negligence. In case of a body corporate holding, dealing, or handling any personal data of customers, and if data is lost due to carelessness on the part of the corporate body, then they are liable to pay compensation to the customers. Okay, the corporate office or the corporate people, the company people, they must be very careful, and they should not be neglect, and because they are dealing with customers. Okay, when they are dealing with customers, these things they should not. In case of a body corporate holding, dealing, or handling any personal data of customers, and if data is, is lost due to carelessness on the part of the corporate body, then they are liable to pay compensation to the customers. Next, penalty for failure to furnish information written. Okay, when whatever it may be the information that was sought by the certifying authority, you have to give that information. You should not be a failure person. That is, there should not be any failure. Penalty for failure to furnish information written. If a party fails to submit any document written or report to the certifying authority or controller, then the party needs to pay a fine up to rupees 1,50,000. Okay, now we are going for one by one the amounts. That is, in monetary terms, we have to pay. If a party fails to submit any document, written, or report to the certifying authority or controller, then the party needs to pay a fine up to rupees 1,50,000. If a party fails to submit any document, report, or any other information to the certifying authority, then the party has to pay a fine up to rupees 50,000 per day. If a party fails to maintain records of the information, books, etc., then the party has to pay a fine up to rupees 10,000 per day until and unless such a failure continues. These are the various amounts that we come across when there is a failure to furnish the information required by the certifying authorities or controller. Now, residuary penalties. What is the remaining penalties? Residuary means remaining. Any violation of the IT rules and regulations and for which no penalty has been fixed, then the concerned party has to pay a fine up to rupees 25,000 for each such contravention. Contravention. Okay. Any violation of the income tax rule, information technology rules and regulations, and for which no penalty has been fixed, then the concerned party has to pay a fine up to rupees 25,000 for each such contravention. Contravention. Now, adjudicating process. The central government must appoint an adjudicating officer to decide whether any contravention of the information technology has taken place or not. Central government will appoint a adjudicating officer. Okay. Next, second one. The officer who has been appointed must be at least of the rank of a director and not below under central or state government. Okay. So he must be at least of a director status or a director's position. The officer who has been appointed must be at least of the rank of a director and not below under central or state government. He should have a good position. It means he should possess judiciary and information technology knowledge. The adjudicating officer must also exercise the powers of a civil court given by Cyber Appellate Tribunal. Okay, the adjudicating officer must also exercise the powers of a civil court given in Cyber Appellate Tribunal. Next, points to be considered by the adjudicating officer. What are the points that he has to keep in his mind? At the time of adjudicating the quantum of compensation to the adjudication officer, he needs to consider the following point. At the time of adjudicating the quantum of compensation, going for the compensation, quantum means the amount of compensation to the adjudication officer, he needs to consider the following points. First one is the unfair advantage taken. The unfair advantage taken. What is the unfair advantage? The amount of loss to the aggrieved party because of the default, the repetitive nature of the default. Okay, these are the various points that an adjudication officer must keep when he want to adjudicate this. Okay, now after that, e-governance. Okay, e-governance. What is this e-governance? It refers to the process of filing and submission of any form or application or any other document with the government department in the electronic format. Okay, this is nothing but it refers to the process of filing and submission of any form or application or any other document with the government department in the electronic format. Example, submission of the passport form online, filing of income tax returns online, e-Seva Kendras for public in paying their bills, and apply for other government services online. At these places, you will come across this e-governance. The main benefit of this is that it is less costly, quick, effective, and efficient in nature. It also ensures accuracy in the performance of transactions. Okay. The main object of this e-governance is it is less costly, quick, effective, and efficient in nature. It also ensures accuracy in the performance of transactions. Now, what are the rules that we will come across when we are going for e-governance? First one is the Act provides the legal recognition of digital signatures, that is, any signed document which is stored in electronic format would be considered as a valid and authenticated electronic record. Okay, it will take into account this digital signatures, legal recognition of the digital signatures. Now, the second point is digital documents include e-filing of income tax returns, e-filing of patents or copyrights applications, etc. The second thing is when you go for e-governance, the rules. A document is considered as an e-document when it meets the following two conditions. Okay, what are the conditions that we come across when you want to recognize a document as an e-document, electronic document? When the document is present in the electronic format as an electronic record, okay, is present in the electronic format as an electronic record. When the document is used for a future reference, okay. Next, the legal recognition of digital signatures. Next, any e-document bearing the signature of a person would be considered as a valid digital signature. That is, whatever it may be, the e-document that was signed by a person. Okay, we have to consider that whether the digital signature is good or not, is valid or not. Signature includes the handwritten sign or any other valid mark or stamp on the e-document. Okay, when you go for this signature, it must be handwritten sign. First one is, or any other valid mark or stamp on the e-document. In the present day electronic world, e-governance has become an integral part of day-to-day life. Okay. Now, when you take into account the current situation, this e-governance, it became a part and parcel of day-to-day life. Next, models of e-governance. What are the various models? We'll come across e-governance models. Government to citizen will in small it is G to C. We will call that thing as G2C. This is nothing but the abbreviation, and the full form is government to citizen. The model of e-governance will connect the citizens of a country to the government It employs various democratic and public services. The government can contact their citizens and can listen to their suggestions, thereby improving the society. The services are okay. The government, it will go for the citizens. It will take into account the citizens of a country, and it will take their suggestions, various suggestions from the citizens of the country. Okay, the model of e-governance will connect the citizens of a country to their government. It employs various democratic and public services. The government can contact their citizens and can listen to their sessions, thereby improving the society. The services are, what are the services? E-citizen, okay, electronic citizen. Okay. This will provide integrated service centers like eSeva, which offers many services to citizens at one place. Example, issue of certificates, ration cards, payment of bills and taxes, submission of passport applications, etc. These are the various examples that we come across when we go for each citizen. Next, e-transport, electronic transport. These centers will provide the RTA related services, including registration of motor vehicles, issuing of driving licenses, tax and fee collection, etc. This is e-transportation. When you want to get a license, you have to go for this. Next, e-education, electronic education. These centers will provide educational services to citizens. Next, e-medicines, electronic medicines. Hospitals of different states are linked to provide a collaborative and improved medical services. Okay, various hospitals, they are coming together and they are providing. Next, e-registration, electronic registration. It provides services for registration of properties, transfer of properties, payment of tax, duty, etc. The citizens services aim to improve the service in five dimensions. They are speed, quality, reliability, convenience, and cost. These are the five things that we come across when we are going for this, okay, e-governance or e-registration. The citizens services aim to improve the service in five dimensions. Different. They are speed, quality, reliability, convenience, and cost. These are the five dimensions that the e-governance people, they'll take into account. Consumer to government, C2Z. Consumer to government, C2Z. Okay, this model deals with interaction of citizens with government. Applications like electronic voting, census, tax payments, etc., comes under this model. Next, okay, G2B, that is government to business. G2B, industries, businesses, or enterprises are chief sources of income to a country. Business requires a lot of interaction with the government. A service named e-taxation, electronic taxation, will provide a business with all these models to develop government to business government to business services. Government must implement standards, provide provide secure payment mechanisms, secured payment mechanisms, implement public key infrastructure, PKT. We'll call that thing as PKT, public key infrastructure for performing secure and authentic transactions. For performing secure and authentic transactions. Next, G2N, government to NGOs. Okay, government to NGOs. This model of e-governance aims at building connections between government and non-government organizations, which help in the betterment of the society. It can be achieved through interaction and publication. This is about G2N, government to NGOs. Next, government to government, G2G. It aims at developing and improving government process. It also it is also known as e-administration, electronic administration. Okay, it is also known as electronic administration. This model involves linking of all government offices into a network so that they can carry out administrative jobs. The most important areas are e-secretariat, electronic secretariat, aims at linking various government various government departments such that they can be that there can be efficient exchange of information among them. Government departments, from one government department to another government department, there should be a link. For that, this e-governance aims. E-policy, electronic policy, aims at keeping track of both police personnel and criminals. No, not e-policy, e-police, electronic police, aims at keeping track of both police personnel and criminals. The personal database will store records of police officers, their previous posting, specialization, etc. This information will help in intelligent postings and promotion of police officers. The e-police service also includes online FIR filing, finding case status, etc. These things you will come across. E-police. Now, e-court, electronic court. This area aims at transforming the manual legal system to an automated system. The judges of Supreme Court and High Court can consider appeals from a remote location using the internet. From a remote location using the internet, the judges can give their decisions online based on the recorded facts of the case. This is about the e-court. All these things will come under this e-governance case. Now, what is the significance of this? The Information Technology Act plays a significant role in regulating the cyber crimes prevailing in India. It was introduced for providing legal recognition for all business activities taking place in cyberspace electronically. Following points highlight the significance. Okay, what are the points that signifies the cyberspace electronically? Following points highlights the significance. First one is it helps in controlling, regulating, and protecting the online business transactions. First one is. The second one is information technology. I'm talking about information technology, Amma. It helps in controlling, regulating, and protecting the online business transactions. It helps business organizations to maintain proper business records electronically. It helps to regulate all types of cyber crimes piracy, hacking, tampering, etc. It provides legal recognition to digital signature which need to authenticated by the authorized person. It provides protection to the data of companies if the data is hacked or copied or destroyed. It provides compensation to the victims against the cyber crimes or damages occurred due to any crime activity. It encourages the use of electronic storage of data and information. It facilitates electronic governance and electronic commerce. It enacted various cyber laws, affiliate tribunals to deal with the matters of cyber crimes against adjudicating authorities. It allows electronic filing of documents with government agencies or departments with full protection. It helps in online business transactions or transfer of money by providing legal recognition to banks. It is significant in case of taking actions It is significant in case of taking actions against the offences related to cybercrimes and punishment against the criminal activities. These are the various points that we come across under the significance of Information Technology Act of 2000. Thus, the Information Technology Act is very significant in the current business environment because in current scenario, internet is internet is becoming common, and through internet only every business transaction is processed. This is about the Information Technology Act of 2000. So with this we have completed this Information Technology Act of 2000, and we are going to step into the further topics. Okay, so with this I'm stopping, and tomorrow I'm going to continue this.